And we want to jump back to Andrew Rodenhouse, who's been watching this trial all day long. Andrew, I have some questions about the jury. We found out that the jury is actually able to ask questions during this trial. Now, we haven't seen any jurors do that just yet, but I hear that that's not common.
It's not common if you look at the entirety of the United States. Michigan is one of the few states that allows this for the jurors to ask questions. Um, and it's kind of up to the individual judges on whether or not they want to allow the questioning. Parties can object to it or request it. With Judge Mims, when I've tried cases with her in the past, she typically allows it. I don't really have a, I don't have one feeling one way or the other about it. Sometimes you get a sense for what a jurors are listening for by through their questions, and just because they ask a question doesn't mean that they're going to get their question answered. So their questions are subject to the normal rules of evidence as if the lawyers were asking questions of the witnesses.
And that was my next question of whether or not jurors being able to ask questions will sway the case one way or another. But do you think that this could help them kind of understand what's happening in this trial? I know that both the defense and the prosecution has really honed in on the fact of this being justified rather than staying around, the other narratives of this case, but really just focusing in on the justification of it. So do you
Yeah,
think
it
that?
can be helpful. It definitely is. It can be helpful for the jurors to be able to ask questions. There's sometimes a juror might ask a question that the lawyers weren't even thinking about, and it's like they totally forgot or missed or skipped part of the story that the jury might think is important, and so then you can go back and answer that question and provide more insight. At the end of the day, the whole thing is about making sure the jurors themselves feel comfortable in understanding the facts of the case.
And I want to go back to your point earlier today where you talked about wondering and seeing if Schurr will actually take the stand. Can you speak on whether or not that is a good or bad thing for this trial?
Well, that's between him and his attorneys. Let me explain to you what you have it when you're a criminal defendant. There are rights that you have, and one of them is you have the right to remain silent and not have your silence used against you. And if he chooses to remain silent, he will be entitled to an instruction from the judge telling the jury not to read anything into that. Oftentimes, in the jury questioning, when at the beginning, when in voir dire, attorneys will oftentimes ask, "Well, what do you think about that? Would you be able to not hold their silence against them?" But the other right that defendants have is they have the absolute right to testify, and the lawyer can't stop them from testifying. And so, if a defendant says they absolutely want to testify, um, then nobody can stop them. The court can't stop them. Nobody can stop them. And so, unless until they act out, or if they, do something to disturb the trial with their testimony. But most defendants, will consult with their attorneys and will agree upon a strategy and practice their testimony, just like any other witness that prepares for trial will meet with the lawyers and practice what they want to say. I've in self-defense cases, I can't recall a single time a person in a self-defense case didn't testify and then went on to prevail in trial. I think it's important in self-defense cases to have the defendant testify. But again, that's a strategy between the lawyers and the defendant. And sometimes defendants just aren't comfortable testifying and just and, and they wouldn't do a very good job, and they wouldn't necessarily help themselves. But in self-defense cases, I think that you got to explain, like, what was I feeling, what was I hearing, what was going through my mind to say that this was justified.
And I want to go back to your point about this being a self-defense case. We've seen a lot of people on both sides talking about what they believe this case is really about. But can you, at its root, at its core, explain to people what both sides are trying to prove in this case?
Well, so let's just talk about what justification means. The jury was instructed already. I listened to the model instructions this morning. There was nothing noteworthy about them other than that they were very standard instructions. And I've heard those instructions given. I came countless times, hundreds of times. And so there was nothing that stuck out to me. But one of the things that's important is that in second-degree murder, that the killing was done without justification. Mr. Becker's arguing that Mr. Schurr was not justified when he shot Patrick, but the defense team is saying no, he was justified, that this was self-defense, that he has a right to go home to his family, and he has a right to not suffer great bodily harm, or be put in a position of great bodily harm, or be put in a position where he ultimately would be killed. And so what I found noteworthy in Ms. Hamilton's argument was she said that he has a right to go home. And I think that's a powerful argument that goes to what a juror would consider when they're thinking about, like, inevitably a juror is going to think about, what would I do in that situation? And that's part of their deliberation, is what would you do in that situation? And how would you react? Because there's two parts to the jury instruction on self-defense. It's a reasonable person, and it's what that person thought and when committing the act. And so it's a two-part test. There's going to be a lot of instructions that will come later at the close of proofs that the judge will give to the jury on what is lawful self-defense. There's a lot of standard instructions that have come down through the years and has developed through our court system. You got to remember that we inherited this right from the English common law, and so there's literally centuries of common law on what this doctrine is.
And you just said something I think that people will resonate with, is what would I would do in this situation. And we've been able to hear from people that were witnesses to this and be able to say what they did in that situation. I want to get your opinion on those witnesses. Did anything stand out to you when they were speaking today?
We had 3 lay witnesses so far. The first 2 witnesses, I don't think helped or hurt anybody. They're just kind of setting the context for what's going on. And part of the job of the prosecutor is to tell a story too. This didn't just happen, on a nondescript day in April. I mean, and Mr. Becker pointed out that it was raining, it was cold. And so those witnesses kind of provide that context. I thought it was the third witness, and I forget his name. I should have jotted it down, but the one that took the cell phone video from his house. I thought he provided a lot of context for the prosecution. Him being there and yelling for Patrick to get on the ground, I think that helps provide some more context to the jury. I don't think he was particularly hurtful to the defense either, because I think he kind of said that he missed about 6 seconds of it. And again, it's going to be, what does the jury think? I mean, this whole thing is caught on video from multiple angles, and so it's not like a case where there's back in the day that we didn't have video, and so you just went to trial and it was just witnesses' testimony. What could they see and hear? And so again, this trial is not going to be won or lost on the first 3 witnesses. There's another thing I wanted to mention to everybody that's watching at home, is that lawyers call it, the trials have life, and they take on a life of their own. And so what we're seeing and hearing, and this goes to one of the points that you guys made on the break, is that we're watching this live. We're all just kind of learning it together. And what you're going to see is that as the trial progresses, the trial itself has a life. And inside the trial, there's going to be different things that happen that are going to be different than what anyone anticipated. And so a trial attorney might go into the trial saying, these are the witnesses I want to call, this is how I want it to go, this is how we're going to present the prosecution, this is how we're going to present the defense. And then all of a sudden you get in trial, and the trial takes on its own life, and next thing you know, you're just off doing something completely different than what you had anticipated at the beginning. And so we're all going to get to watch that and up front, and through 13 plus, we're going to all get to see how this goes.
And I want to ask, when you say that a trial can take a life of itself, how do you, as a lawyer, plan for that? How do you continue to prove your case if things are constantly changing?
You do it by training and experience, and by doing it enough times so that you get to a point where you're like, I've seen and heard everything. I anticipate almost everything. And then something happens where you're like, I've done this hundreds of times, and now I have a new situation that we've never dealt with before, and now we have to try to figure out how to deal with it. And it's one of the things that I enjoy about doing trials. It's why I do that as a career, because it's just exciting to be in that arena and fighting. And so there's a lot. But it's highly stressful, and you just deal with it by doing it enough times that it becomes normal.
And I wanted to just go right back to the last witness that we saw. We saw he was very emotional, you know, saying things at times where he had to be instructed to just stick to what he saw rather than kind of not putting his input, but feelings of what he may feel. What do you take from that? Does that, you know, hurt one side or the other? Does that make it more, yeah, what's your opinion?
I don't think it hurts or helps any side, but what it does is it tells a story, and it provides context and color to the story. So you got to remember that this didn't just happen any old place, any old time, any old April. I mean, it happened when it happened in relationship to everything else that was happening all over the country. And that's what makes this story so big. And so when he said that all of a sudden it's in his front yard, like what he had seen on the news with George Floyd and all the stuff that's going on all over the country, all of a sudden, all of it is in his front yard and it's outside his door. And he knew that. He knew at the time it was happening that it was important to document it. That's why he ran inside and grabbed his phone. And that's why he was yelling at Patrick to just get down. And he said that this is, he wasn't surprised by how it turned out.
Well, Andrew, we really appreciate you coming on and just giving us some more clarity as to what goes on to this case. And we know that we will be tapping into you more as we continue our coverage. So thank you again for joining us.
You're very welcome. Have a good afternoon.
You too.